Welcome to our webinar, UCC Debtor Names, What You Don't Know Can Hurt You. My name is Anu Shah and I will be your moderator. Joining us today is Paul Hodnefield. Paul is an Associate General Counsel for a corporate service company and serves as the company's subject matter resource for UCC, real estate, and other transactional service matters. He is a frequent speaker and writer on UCC search and filing issues and a 2013 recipient of National Association of Secretaries of State Medallion Award. And with that, let's welcome Paul.
Thank you. There is no piece of information on a financing statement more important than the debtor name. UCC Article 9 has some very strict rules for how the debtor name must be provided, and failure to comply with those rules has rather harsh consequences for the secured party. Therefore, it is critical that those who file UCC records, and to a lesser degree those who search UCC records, understand how to correctly provide the debtor name for purposes of the financing statement. Now, this isn't always an easy task, and for a number of reasons. First and foremost is that the debtor name rules are not intuitive. Relying on common sense and general understanding can be very risky in this process. Another challenge is that the rules are actually more simple than many filers realize. As a result, there tends to be, some filers tend to overcomplicate the process for determining the correct name of the debtor. It is also possible for filers to get a little too complacent when it comes to preparing UCC records. From about 2003 through approximately 2011, there was a steady stream of court cases on individual debtor name issues that continually reinforced to those who file UCC records that even this most seemingly minor error in the debtor name could carry exceedingly harsh consequences. Since about 2011, there have been almost no debtor name cases, very, very few. The courts just have not addressed them. The issue hasn't been before the courts. And this is not because there are fewer debtor name errors necessarily. It isn't difficult to go into a state UCC index and find a host of debtor name errors without looking very hard at all. More likely, the reason for the lack of recent case law is simply that secured parties know when they've lost. It's a very clear precedent that's out there. And as a result, they're not going to waste time and money trying to litigate the matter unless there truly is a novel issue. And because there aren't these cases being handed down on a regular basis, filers don't hear about them like they did during that period, and as a result, there is a possibility of getting a little more complacent. But it is as important as ever for commercial lenders and their legal counsel to fully understand the debtor name sufficiency rules for UCC financing statements. Today, I'll explain those rules by beginning with the essential concepts about debtor names, and then moving on and talking about the specific rules for the different types of debtors or based upon the status of the collateral. Now, at the end of the program, I will take questions as well with any remaining time. So without any further ado, let's go ahead and begin the program. To begin with, I want to cover some essential concepts about debtor names. To begin with, I think the most important thing is to understand why the debtor name is on the financing statement to begin with. I mean, what is the purpose of the debtor name on the financing statement? If you take a look at this and treat it kind of as a multiple choice test where you can choose more than one correct answer, I think many people would select two or more of these four possible reasons. But in fact, there is one purpose and one purpose only why a debtor name appears on the financing statement, and that is to allow retrieval of the record. It's not there to identify the debtor. Anybody searching the UCC records by debtor name already knows who the debtor is. It's not there to communicate information about the debtor. It's not there to indicate the capacity of the debtor. The only reason why it is on the financing statement is to allow retrieval of the record using clear and consistent rules. And because of this sole purpose of the name on the financing statement, the name required for purposes of the financing statement, the rules for determining that are not intuitive. In some cases, the name required for purposes of the financing statement is not the name of the debtor. It's a name used to represent the debtor to allow for expediency in the retrieval process. And what it really boils down to with the secured party name or the debtor name rules as well is that the burden is on the secured party to get it right. Searchers are not expected to go figure out what all the possible different names under which a UCC record could be filed and then search each. It's the secured party's responsibility to get that name right, and that's noted in the official comments to Article 9, and as we'll see here in a minute, it's also embedded in the statute based on the allocation of risk. A couple other essential concepts to understand about the debtor name rules. One is that whatever goes in the name field is the debtor name. And that's because the filing offices are required to index the contents of the name field exactly as it's presented to them. So they are going to enter that string of characters that's in the name field exactly as it appears, even if there's a blatant error in there that any human could see. And that's because when it comes to indexing, judgment discretion have been removed from the filing office. It's up to the filer to get it right, so they just enter it exactly as it appears. And as a result, if it goes in the name field, it becomes part of the debtor name, whether it's intended to be part of the debtor name or not. And a corollary to that is if it's not in the name field, the debtor name isn't provided. It doesn't go on an attached schedule or something like that. If it goes on an attached schedule, it's not in the debtor name field. The filing office won't index that because they're not required to look around and try to determine what the filer intended. The way they determine what the filer intended is whether the name is in the name field. And there's a case out there that illustrates this. In Ray Camtech, the secured party put two debtor names on an attached schedule rather than using addendum forms which have debtor name fields. And by putting them on attached schedules, the court held they weren't provided, so the secured party wasn't perfected with respect to those debtors. So be sure to put them in the debtor name fields. Now when it comes to debtor name sufficiency, it's really important to understand the general rules related to sufficiency. The rules for the specific debtor names that are required for purposes of the financing statement are found in Section 9503A. And these are based upon the particular type of debtor or the status of the collateral. In certain cases, the status of the collateral determines what name is required for purposes of the financing statement. Now, if a secured party fails to provide the name required by Section 9503A, then under Section 9506B, the financing statement is seriously misleading and not effective. Now, when it comes to providing the correct name, it has to be precise. Even a comma out of place means it's not the correct name of the debtor. And then 9506B will kick in and make it seriously misleading and not effective. Although there is an exception, and this is an important exception. And that is, under Section 9506C, if a search of the records of the filing office under the debtor's correct name using the jurisdiction's standard search logic would disclose the record, then the name or the financing statement that fails to sufficiently provide the debtor name, it does not make the financing statement seriously misleading. So in other words, if a search using the jurisdiction standard search logic would find it, then it doesn't matter at that point in time if the debtor name doesn't comply with Section 9503A. So when we boil it all down, we've got two different options here. One, either the debtor name strictly complies with the name requirements of Section 9503A, and again, I mean strictly. It has to be an exact match to how that name appears on the source document for that name as specified in Article 9. If there's any deviation whatsoever, then it's not the name of the debtor. But if it does comply with Section 9503A, then the secured party is going to be perfected, even if the filing office makes an indexing error or something like that. The secured party, if they get it right, they have those protections. Now, if the name doesn't comply with Section 9503A, then we have the alternative test. If it doesn't comply with 9503A, then we do a search of the correct debtor name using the jurisdiction standard search logic, and if the record is disclosed, then the financing statement is not seriously misleading. However, the protection offered by standard search logic and by 9506C is actually very limited. It's really important to understand how that search logic works, so I'm going to run through that in a nutshell. The idea behind the model standard search logic in Section 9506C is to protect filers from very minor errors in a debtor name, a deviation in punctuation that's really non-substantive. And it does this by disregarding certain parts of a name, punctuation, spacing, ending noise words, and at the beginning of the name. And it does this through a normalization process. What happens is the name that's provided on the financing statement is entered into the searchable index, and then the computer takes that name and it runs it through a multi-step process. First, it makes it case neutral. Then it removes punctuation. It strips out the ending noise words. It disregards the from the beginning of the name, and then it deletes the spacing. And what you're left with is a string of text derived from the name on the financing statement. Then when somebody conducts a search, the name searched is run through the same normalization process, and at that point, after both the search name has been normalized and the financing statement name has been normalized, does the computer match and report only exact matches at that point. Now again, remember, whatever goes in the name field gets run through that normalization process, and whether it's intended to be part of the name or not, it becomes part of the name. I mean, here's an example of how it can work in real life. At the top there on the left, you see the name as it appears in the source document for this debtor. This is the statutory source document for purposes of Section 9503A. If you look to the right, you see in box 1A, that is how the name appears on the financing statement, and the filer has added some descriptive information in there. Now, you and I looking at this know it's the same debtor, but it's not a human standard to determine whether a debtor name is correct or not. It's a computer standard, and computers don't read, think, comprehend, or understand. All they do is match. So if we take a look at this, because the string of text on the financing statement does not equal the string of text for the correct name of the debtor, it's not the correct name of the debtor, and as a result, it's only going to be sufficient if a search using the jurisdiction standard search logic would disclose the record. Well, in this case, when we run through the normalization process, we're going to take that name, we're going to make it case neutral, strip out the punctuation, the ending noise words, we'll delete the spaces, there's no leading the to remove, and what you wind up with is the normalized name on the correct name on the public organic record here, and the name on the financing statement. And if you look at the normalized names in both cases, they don't match. As a result, the name on the financing statement, because it's not the name of the debtor required by 9503A, and they don't match in the normalized strings, that means it won't be disclosed on the record. Consequently, financing statement is seriously misleading and not effective. So there's not a lot of margin for error in here. Moreover, there are other issues with standard search logic. About 2/3 of the states out there use the type of search logic I've just described. They use, but they don't use it consistently. Each one had to program its own search logic. So there's some variances of interpretation as to what the normalization steps mean. So you get some differences in how many times it'll go through and remove noise words. The states have different noise word lists. It's not consistent. Not all punctuation is treated as punctuation by all states. For example, the ampersand in some states is deemed the equivalent of the word and. In other states, it's deleted as punctuation, and in other states, it's determined to be the equivalent of a word, but it's different than and. So it's left in during the normalization process. States really struggle with any type of character or symbol that isn't found on a standard keyboard. And spacing can make a difference. Even though it does delete spaces, some states have programmed their search logic to delete one space, but not two. So that can affect it. And then to complicate matters further, there are states that don't follow the model standard search logic. The model standard search logic comes from the IACA model administrative rules for Article 9. Those are sometimes called MARS. And there are a number of states that have the non-MARS search logic. Some states like Florida and Alaska, they use a phone book style search logic. Others use an exact match like Utah, and others have different variations. And filers, if they're at the mercy of the search logic, they're at the mercy of the search logic of the particular state that they filed in. There isn't a lot of room for error. The search logic simply isn't going to prevent a lot of errors from making a record seriously misleading. So even if the search logic does save a financing statement that has a non-compliant debtor name, the filer should never rely on that savings clause. Amongst other things, what happens if the search logic changes? If the filer didn't provide the debtor name correctly, I think there's a very good chance that the courts would determine that, well, they're at the mercy of the search logic changed, tough, it doesn't show up anymore. And you have no way of proving that it showed up before the search logic changed. So never rely on the standard search logic. Get the debtor name right. Get it precise. So with that, now I want to talk about the specific types of debtors in collateral situations and what's required for those debtors and collateral types. We'll begin with the most common type of debtor in a commercial loan transaction, and that will be the registered organization. Article 9 defines registered organization to mean an entity formed or organized by the filing of or issuance of a public organic record or the enactment of legislation. This is going to include corporations, LLCs, and similar entities. Now, if the debtor is a registered organization, the financing statement is sufficient only if it provides the name stated to be the name of the organization on the public organic record, most recently filed with or issued by or enacted by a jurisdiction. So we have to actually look at the definition of what a public organic record is, because clearly the public organic record is the source of the debtor name of a registered organization for purposes of the financing statement. Now, a public organic record is defined by Article 9, and it means the record initially filed with or issued by a state or the U.S. that forms an entity. It also includes legislation that creates an entity. It includes the record of a business trust that's required to be filed as a public record under state business trust law. And it includes any record filed to amend or restate the name on any of those records I've just mentioned. So, for example, a public organic record would, in this type of case, would mean the articles of incorporation for a corporation, the articles of organization for an LLC. It would include the declaration of trust that has to be filed with the state for a business trust. It would also include the legislation that formed a public type of entity, such as Fannie Mae or Freddie Mac. So public organic record, and of course if they've been amended to change the name, it's the amendment, the most recently filed public organic record. There are also some things that people sometimes think provide a source of registered organization names that are not a public organic record. Most specifically, a certificate of good standing. That isn't the name necessarily that's on the public organic record. And likewise, the state online business entity database is not a public organic record. It's not the record that formed or organized the entity. And as a result, the state online business entity database may be different from the name found on the public organic record. In fact, the name on the certificate of good standing usually comes directly out of the business entity database. So neither one of those should be used as the source of a debtor name for a registered organization unless the secured party is willing to accept a certain degree of risk. So after running through, bearing in mind the search logic performance I talked about and the requirements for a registered organization to provide the name on the public organic record, let's take a look at some examples. This is something we see from time to time. It's common error. Here somebody has provided actually the correct name of the registered organization, Jim Ross Tires, Inc., but then they've added more to it. They've added DBA, HTC, Tire, and Automotive Centers. First thing, bear in mind that under Article 9, a trade name is neither necessary nor sufficient for purposes of the financing statement. In other words, providing a debtor's trade name is not sufficient. It's not required on the financing statement. If it is provided in the debtor name field with the correct name of the debtor, well, the correct name of the debtor now forms only part of the debtor name, and the debtor name is this entire string of characters. Now, this particular example came out of a court case, and what happened was the debtor had filed for bankruptcy. The secured party that filed this financing statement found itself being challenged, and the secured party argued that once you get the correct name of the debtor on there, everything after that should just be disregarded. But the court correctly pointed out that the filing office is required to index that entire string of characters. And by indexing that entire string of characters, that becomes the debtor name. And by adding all these extra characters in there into the searchable index, that will inevitably cause the standard search logic to not find this financing statement. So it's not the name of the debtor, and with the extra text in there, it's going to prevent the search from finding it. As a result, it's going to be seriously misleading and not effective. That's what the court found. Here we have another example. We have the Aspen Utility Company, LLC, but we have a little boo-boo in here. Somebody was a little fast on the keyboard and misspelled the. Well, some people might think, well, it doesn't really matter because the at the beginning is disregarded, and that is true in most states, but we don't have the at the beginning of the name. We have TEH, and the computer isn't that smart. It sees TEH at the beginning of the name. It doesn't disregard it. So somebody who is searching the Aspen Utility Company, LLC, the computer is going to compare Aspen Utility to TEH Aspen Utility after the ending noise words are disregarded. It's not the name of the debtor, and it won't show up on a search, seriously misleading and not effective. Another example. Here we have KWM Electronics Corporation. This is what was filed on the financing statement. However, if you look to the public organic record, this is the name on the public organic record. And if you look closely at this, you'll find that there were periods after each of those initials, and those periods were omitted from the name on the financing statement. Well, unfortunately for the secured party, this record was filed in Utah. Utah's standard search logic does not disregard punctuation. The court found that this was, without the punctuation, it was not the name of the debtor, and because it didn't show up on a search of the correct name of the debtor, because punctuation is not disregarded on the Utah search logic, the result is that this financing statement was seriously misleading and not effective. Now, if the same thing had happened in a different state, the outcome might have been different. So even the most tiny deviations can have a harsh consequence for the secured party. From a searching perspective, just one thing I want to point out, don't assume just because something is really unusual looking that the name isn't effective. Searchers have a whole different set of concerns than filers do when it comes to looking for debtor names. You know, here, Fisherman's Corner LLC with LLC in quotation marks, I stumbled across this one and I thought, wow, somebody really made a boo-boo here, because if this is in a state that doesn't disregard quotation marks as punctuation, the secured party's in trouble. Until I looked at the public organic record, and lo and behold, the public organic record has the LLC in quotes. Consequently, this is the correct name of the debtor, and the filer got it right. So when it comes to providing the name of a registered organization, the first step is always to conduct thorough due diligence. Taking any shortcuts, like using the online database or certificate of good standing for the source of the name, carries risk. You know, the more due diligence, the better. Of course, it's always a cost-benefit analysis on just how much to do. But for a registered organization, be sure to use the name exactly as it appears on the public organic record, most recently filed with, issued by, or enacted by the state or the U.S. And I mean exactly, with spelling, identical, no abbreviations, identical spelling, spacing needs to be identical, punctuation, word order. I would even go so far as to say upper and lower case should be identical to how it appears on the source document. And never add anything to the name. Don't add in titles or the capacity of a debtor, and this applies not just to registered organizations, but to all types of debtor names. And never put any explanations or descriptive text into that field. It will almost always make the financing statement seriously misleading and not effective. Now I want to move on and talk about the second most common type of debtor out there, and that's the individual. When it comes to individual debtor name rules, there was some controversy over what the best way to approach individual debtor names was during the drafting process for the most recent amendments to Article 9. Ultimately, the drafting committee and the stakeholders arrived at two legislative alternatives that they offered to let the states decide which way they wanted to go. The majority rule today, what most states enacted, is what was called the Alternative A Only If rule. And what that means is that under the Alternative A Only If rule, the financing statement is sufficient only if it provides the name indicated on the individual's driver's license. So though some states added a phrase, driver's license or state-issued ID card. And to be sufficient, though, the driver's license has to be unexpired and issued by the state where the UCC record will be filed. If the debtor doesn't have a driver's license or alternative ID, if the state law allows, then there's a second-tier safe harbor that allows the financing statement to provide the surname and first personal name of the debtor or the individual name of the debtor, whatever that might be. So that's all. And there's about 45 states, if you include D.C., that have the Alternative A rule. The minority rule, with about 6 states, is called Alternative B, the Alternative B safe harbor. Here, the same driver's license rule applies, except it's optional. The financing statement is sufficient only if it provides the individual name of the debtor, the surname and first personal name of the debtor, or the name indicated on the debtor's driver's license that is unexpired and issued by the state of filing. In practice, the driver's license is almost always going to be the starting point. There are some other states and territories, however, that haven't adopted these rules, but all 50 states and D.C. have. Now, because the driver's license is always going to be the starting point for determining the correct name of an individual debtor, it's important to know how to use the driver's license. Remember, I said it has to be unexpired and issued by the state where the UCC is to be filed. So the first step in looking at the driver's license is not to look at the debtor name, but to look at what state issued the driver's license. Is it the state where the debtor is located? If the debtor, like in this case, we have an individual debtor, an individual is going to be located for purposes of Article 9 at his or her principal residence, and the law of that state will govern perfection and priority. Now, people don't always change their driver's license when they move across state lines. So with this example, if this person actually moved to New Jersey 2 years ago and just never changed her New York driver's license, the correct filing location is New Jersey, and therefore a driver's license issued by New York State would not be a sufficient source of a debtor name. However, assuming that this individual does still reside in New York, we still don't look to the name. The next step is to look to the unexpired, or to look to see when the driver's license expires. Here it doesn't expire until October of this year. If we're filing today, then that means the driver's license is unexpired and it's issued by the correct state, so then we can go to the name. But if it has expired, then again, the driver's license is not going to be legally sufficient as the name of the debtor, even though it might provide the exact same name that would be sufficient for purposes of the financing statement. Now, once we've determined that the driver's license is a sufficient source of the name, now we can extract the name to the financing statement. This is an important step because the components of the name on the financing statement may be in a different order than they appear on the driver's license. It's up to the filer to extract the components of the name correctly and map them to the correct fields on the financing statement. And in most cases, that's fairly easy to do, but there are some outliers. There are some exceptions. They don't pop up very often, but when they do, it's necessary to address them. One, for example, what happens if you have more than 3 components of the name? Here we have Mary Ellen K. Johnson. I can tell you that in some states they include no punctuation in driver's licenses. So looking at this, we can't tell if the first name is Mary Ellen or just Mary, with Ellen as the middle name. Likewise, we can't tell if Johnson is the last name or if K-Johnson would be the last name. So how do you get this correctly on the driver's license? Well, or on the financing statement? Well, the problem with this is that it has to be on the financing statement in the form that a court later is going to determine was the correct name of the debtor. The problem is you can't always predict what a court's going to do. So the trick is to file it with name variations so that whatever a court decides was the correct name finds its way onto the financing statement. In some cases that might be for different name variations. Most of the time it won't be. Another issue that can arise, there's plenty of case law out there that says that nicknames are not sufficient as the name of an individual debtor. You can't use Mike for Michael. But those came out before the driver's license rule. Today, how does that play out when it's the name on the driver's license and it displays what apparently is a nickname? Well, in that case, under the current law, the name on the driver's license is the debtor name for purposes of the financing statement, even if it provides a nickname or something like that. So here, because it is the name for purposes of the financing statement, that is the name that has to go on there. Now here's the challenge for the filer. What happens if the debtor later goes down and changes their driver's license so it says Elizabeth instead of Liz? Well, that's a name change event for purposes of Article 9. And states are becoming a little less flexible in allowing people to pick how their name will appear on driver's licenses for a number of reasons, not the least of which is the ability to travel by air these days. So there's always a risk here that somebody's going to change their driver's license, and if that happens, that's a name change event for purposes of Article 9, and the secured party will become unperfected in after acquired collateral unless they file an amendment within 4 months after that name change. The problem for the secured party is that they don't have a way to know about the name change. The debtor probably isn't going to think, oh, they changed, my driver's license changed, I better run down and notify my secured lender. So in this type of situation, it might be a good idea to file as a second debtor the full name, not so that if the driver's license ever does change, the name is already on there. What happens if there's a blatant typo in the debtor name? Well, remember, the name provided on the financing statement is the individual debtor name, or the name on the driver's license is the correct debtor name for purposes of the financing statement. And an error like that is going to have to go right on the financing statement. Now, again, what happens if this person goes down to the DMV and changes her driver's license to be correct? Well, again, that's going to be a name change event for purposes of Article 9. So in this type of situation, best practice would be to file the correct name without the typo as an alternative debtor, and then that way, you know, if there is such a change, then it does need, or it's the financing statement already has it on there, and that will help insulate the secured party against unknown name changes. Another issue with the driver's license, my understanding is there are some states that do allow certain special characters on a driver's license, like the Enya character here, that you know, you might not find on your standard keyboard. If that were to occur, that is the correct name for purposes of the financing statement, and therefore it has to go on the financing statement exactly as it appears on the driver's license. You have to find a way to get that special character on there. Now, this will be very rare. It won't happen very often, but if you ever do come across it, be prepared. And also be aware that that some states will not index this character, and it's very hard to tell how to search for this. So in this type of situation, I would recommend filing as a second debtor the name as somebody is likely to search it. I mean, we file these with the intent that they can be found on a search to avoid future problems. So let's make it easy to find. File it as somebody is likely to search it as an alternative debtor. So when it comes to filing on individual debtors these days, the first step is to confirm that the driver's license or alternative ID is sufficient as the source of the debtor name. Remember, it has to be issued by the state where the record will be filed, and it has to be unexpired. And if the debtor lacks the license or state ID that meets these qualifications, then the filer needs to use the alternative safe harbor options. Once the driver's license is confirmed to be sufficient, though, then the secured party needs to map the name components onto the form into the correct fields. And if there's any question on how to provide the name on the form or its electronic equivalent, then don't be afraid to file name variations as additional debtors to ensure that whatever the court decides was the correct name, which will always be after the fact, that will ensure that whatever the court decides is on the financing statement, hopefully be on the financing statement. And finally, preserve evidence. It's a good idea to retain a copy of the driver's license that the secured party relied on because it's not a public record. There's not necessarily an easy paper trail that somebody can follow to show what the name was at a particular point in time. Once that driver's license changes, there may be no evidence of what it was before. So, you know, preserve that evidence in the files. Now, there are two types of circumstances where the status of the collateral determines what name is required for purposes of the financing statement. One of those is when the collateral is being administered by a decedent's personal representative. In other words, when the collateral is part of a decedent's estate. If the collateral is being administered by a decedent's personal representative, the debtor name is sufficient only if, or the financing statement is sufficient only if it provides the name of the decedent and in a separate part of the financing statement indicates that the collateral is being administered by a personal representative. So there's two requirements, the name of the decedent and an indication. So when filing on this type of debtor, the thing to remember is the name of the decedent is an individual name. It's not an organization name, even though an estate is not an individual. You know, we're using a name to represent the debtor to allow retrieval of the record, not the actual name of the debtor itself. The indication is not part of the debtor name. It is to be provided in a separate part of the financing statement. If it is provided in the debtor name, it will nearly always render the financing statement seriously misleading and not effective. When dealing with this type of debtor name, remember that we're dealing with that individual name. Here we have an example of how people are tempted to provide the name of an estate. And by the way, most of the examples I'm using in this presentation are very recent. Most of them within the last year or two were filed. So this isn't, these aren't old things that have been sitting out there since the old days before 2001. Here we have estate of Paul C. Primus. A number of problems here. First of all, it's in the organization name field. If the name of the decedent is required, it's an individual name. It has to go in the individual name field, Primus in the last name, Paul in the first name, C in the middle name. Plus, it has the indication in the name field. Remember, this has to go in a separate part of the financing statement. If it's added to the name field, this extra text, because it's not part of the name, will prevent a search on the correct name from finding it. Capacity is not part of a debtor name. And in fact, if the collateral is being administered by decedent's personal representative, who may be called an executor, the name of the executor is not sufficient. Proper way to provide this one is Nelson in the last name, Douglas in the first name, me in the middle name. Check the box on the bottom of the form. But here they've just provided a lot of extra information that will prevent it from ever being found in a search, and it won't be the correct name of the debtor. Here we have somebody that provided it as an individual name but included the indication in the name field, in the surname field, rather than in a separate part of the financing statement. That'll make it seriously misleading and not effective every time. Here we have somebody that provided the indication in the suffix field. I don't know if this qualifies as a separate part of the financing statement. Suffix is very closely related to the debtor name field, but I'm not sure if it would count as part of the name or a separate part of the financing statement. So court would have to decide that issue. Definitely not the middle name field. That indication must not be made there. The proper way to make that indication is using the checkbox on the form. So remember, the name of the decedent is an individual name. Use the individual name fields and provide it just as if it was a living person's name. There is a safe harbor for the name of the decedent. A court order appointing a personal representative can serve as the source document for the name of the decedent. And make that indication checking the appropriate box in item 5 of the form or its electronic equivalent. Don't put it in the name field. If the collateral is held in a trust that is not a registered organization, then the financing statement is sufficient only if it provides the name of the trust specified in its organic records, or if no name is specified in the organic record, the name of the settlor or testator. The settlor is the person or entity that created the trust, so is a testator. So it applies to both a trust created by a living person or a trust that's created as part of a last will and testament. And then in a separate part of the financing statement must indicate that the collateral is held in a trust. Now, if the name of the settlor is provided, then there's some additional information that's required. In a separate part of the financing statement, there has to be additional information to distinguish the trust from other trusts with one or more of the same settlors. But again, this is all separate part of the financing statement. So remember, the only names that are permitted are the names of the trust or the name of the settlor of an unnamed trust. The name of the trustee is not sufficient, even though the trustee typically is going to be the debtor, the actual debtor, when the collateral is held in a common law trust. The trustee is the one granting the security interest. But don't confuse the name of the debtor, of the actual debtor, with the name of the debtor that's required for purposes of the financing statement. They may be different. The additional information and the trust indication is not part of the debtor name. It is required to be provided in a separate part of the financing statement, and use the checkbox to make the indication that's required. I mean, there are a lot of different ways people provide trust names. And if you look at these 5 examples, these are all filed covering collateral held in the same trust. Yet we've got 5 different names. Which name is correct? I don't know if any of them are correct, because you have to start with the organic record of the trust. That's the only way that somebody preparing a financing statement can know what name is required. It's either the name of the trust or the name of the settlor. Here we have, they provided the Clarence A. Griefinger Declaration of Trust Agreement dated April 22nd, 1996. In other words, they're naming the trust agreement as the debtor. No, it's the name of the trust or the name of the settlor, not the agreement. The agreement cannot be a debtor. Here we've got the name of the trustee that's been provided. The name of the trustee is not sufficient, and even if it was, the name of the trustee, adding the word trustee is adding a statement of capacity, and that's not part of a debtor name. So, the name of the trustee is typically not sufficient unless the trustee is also the settlor of an unnamed trust, but then the name is being provided in the capacity of settlor. Nevertheless, adding capacity to the name provided on the financing statement is going to be a problem. Here we have, they're giving information in the name field that is not part of the name. They're describing the agreement. Well, that's helpful to distinguish from other trusts with the same settlor or settlors, but remember, it goes in a separate part of the financing statement. And here again, we have the name of the settlor. It's a registered organization, Joe Techie Inc., and so it's provided correctly in the organization name field, but it includes a statement of capacity, and it describes the trust. The debtor name that the secured party has provided here is that full string of text. That full string of text doesn't equal the correct name of the settlor, which is simply Joe Techie Inc. As a result, it's not the name of the debtor, and it will prevent the financing statement from being effective because it won't show up on a search. In fact, long trust names are almost always a red flag. That if it's a long name, it generally means that they're providing extra information that doesn't belong as part of the debtor name. Here, the secured party has provided the name of the trustee and a whole list of the succession of trustees and name changes and everything. The only problem with this 458-character debtor name is that the state where this was filed can't even index that many characters. In fact, it gets cut off on the third line, and the only unique identifier in that whole thing would be trust number 315, and because that appears at the end, it never makes it into the index, and there's no search in the world that's going to find this. It's not the name of the debtor. The extra text means it'll never show up on a search. Good rule of thumb. If a financing statement, if the name on the financing statement ever exceeds the space provided, one line, that's probably because it contains information that would render it seriously misleading. So again, a good rule of thumb, it's a red flag if the debtor name can't easily fit within the space provided on the form or its electronic equivalent. So when dealing with trust-related financing statements, always start with the trust's organic record. Without it, the filer cannot know whether the name of the trust or the name of the settlor is required. There is a safe harbor for the name of the settlor or the testator, and that's the name indicated on the trust's organic record for the settlor or testator, unless the settlor is a registered organization, in which case they're treated as a registered organization. Determine the type of, what type of name. If it's an organization name, it goes in the organization name field. If it's an individual name of a settlor, it goes in the individual name field. And make sure to provide it correctly. Don't include statements of capacity or additional descriptive information to distinguish from other trusts. All that goes in a separate part of the financing statement. Now, for any other type of organization, the name that's required is the name of the debtor. It's a catch-all provision. So it's really left to the best judgment of the filer. So it's the filer's best judgment that's going to determine what the name is. There's been one case on this. It was only a couple of years ago where the individual names of joint venture partners were not required because there was a name for the joint venture, and therefore they didn't have to have the individual names. But the filer there determined that what the name of the joint venture was by conducting adequate due diligence to determine that. So when it comes to other organizations, conduct thorough due diligence into what the organization's name can be, review all the official documents, and again, it's not a registered organization, so there's not going to be that public record of what the name is. So if more than one name could be correct, don't be afraid to file possible name variations as additional debtors. And finally, what does somebody do if the debtor doesn't have a name? Well, under Article 9, if the debtor doesn't have a name, then the financing statement must provide the names of the partners, members, associates, and other persons comprising the debtor, and the name must be provided as if those parties were debtors in their own right. So list them each as a separate debtor. And beware, if there is an unnamed debtor, don't be tempted to create a name. Don't assume that it must have a name if it doesn't appear to have one. You can certainly file under what could possibly be correct, but if it's not clear that the debtor has a name, file in addition to what name or names might be. Be sure to include the names of the parties that comprise the debtor, all listed as separate debtors. To wrap up here, just a couple of additional resources. We do have some debtor name resources on CSC Transaction Watch, including a 50-state survey and checklist of individual debtor name requirements. I also recommend looking at the official comments that are relative to debtor names found in Article 9. The official comments oftentimes explain in more detail what really is required. And these you typically aren't going to find in the statutes. You're going to have to look to the probably the official publication of the Uniform Law Commission of the UCC. And it also helps to have the IACA model administrative rules, which are what most states follow when it comes to how they handle debtor names during indexing. They will explain what goes into a name and, more importantly, what doesn't go into a name in those rules, and most states do follow those. So with that, I'm going to wrap up the presentation. You can download a copy from Adobe Connect here, and my contact information will be on there. I'm going to take questions here in just a minute, but if you think of questions after the fact, you can always feel free to contact me directly. So with that, Anu, I'm going to turn it back over to you for Q&A.
Thank you, Paul. That was great. We will now open up the Q&A session. Also on the screen, we have one last question for you. Would you like to be contacted by a UCC specialist? We'll keep this up so you can make your selections throughout the Q&A session. And also, just as a reminder, you can download a copy of today's materials from the handouts box. And if you'd like to see what other webinars CSC offers, click on the free education webinars link in the Join Us for More box. So now let's take some questions from the audience. Paul Patty wrote in, do you have to have an unexpired driver's license before renewing a UCC?
It's a good idea, because if the driver's license has expired, then that can create a name change. For example, let's say the driver's license provides the first name of Mike, and it expires. Then it doesn't serve as the sufficient source of the name anymore, and that may be a name change event for purposes of Article 9. And under the case law that's out there, Mike is not sufficient for Michael, so the secured party is going to become unperfected. And if they continue, I should say they'll become unperfected, and after acquired property, their existing collateral they'll remain perfected in. But usually around continuation time is a good time to check and verify that the driver's license is still unexpired and that there's been no change in the driver's license. But you can continue it without doing it. But it's a good time to check and make sure the name is still the correct name.
Great, thank you. Linda wrote in, what is the most reliable source for verification of debtor name?
It depends on the type of debtor. For a registered organization, it's the public organic record. That's the only sufficient source of the debtor name. For an individual, it's the starting point is always the driver's license, although that may not be sufficient if it's unexpired or issued by the wrong state. For a decedent's estate, it's the name of the decedent, and if there's a court order appointing a personal representative, it would be the name of the decedent indicated on that court order. And for a trust, it's always the organic record of the trust. For any other type of debtor, there is no hard and fast rule as to what the source of the name is. You have to go conduct thorough due diligence, determine what name or names could be correct, and then file on any possibly correct variations.
Great, thank you. Anne wrote in, should the entity description be added at the end of the debtor name? I frequently see ABC LLC, the state name, limited liability company.
Yeah, this happens all the time. You'll see XYZ LLC, a Texas limited liability company, and if that is added on to the end of the name, it will, in nearly all cases, render the financing statement seriously misleading. Because with that extra text in there, the string of text in the name field is not the string of text that represents the correct name of the debtor. And because it's not the correct name of the debtor, that means it's only going to be sufficient if it shows up on a search using the jurisdiction standard search logic. And while the ending there, the limited liability company, would be disregarded, Texas is not an ending noise word and would not be disregarded. So there, a search of the correct name would normalize to, if it was XYZ LLC, that would normalize to just XYZ, whereas XYZ LLC, a Texas limited liability company, would normalize to XYZ LLC, a Texas. And as a result, the two strings aren't going to match. It'll be seriously misleading and not effective. Use the name exactly as it appears in the source document. Do not ever add anything to the name. It will, in most cases, result in a seriously misleading financing statement.
Okay, thank you. Trish is asking, on individual name variations, are we to add all of the variations to the security agreement as well?
That's not necessary. The security agreement is a different purpose. That's what defines the rights of the parties. Normal contract law pretty much applies to that, as well as the Article 9 security agreement requirements. But remember that the financing statement is just a notice, and it's out there to be found. The debtor name on the security agreement is there to bind the debtor. The debtor name on the UCC record, the financing statement, is there to allow retrieval of the record. So it's apples and oranges. No need to add all those to the security agreement. It's a whole different purpose for that type of record.
Okay. Let's take one more question. Jody's asking, what are safe harbor options? Birth certificate, any others?
No, birth certificate is not a safe harbor option. There are two safe harbor options if a safe harbor applies to an individual debtor name, and that is the surname and first personal name of the debtor, in other words, just the last name and first name, or the individual name of the debtor, which is what the standard was before the recent amendments took effect in most states in 2013, which is kind of a vague standard. It's one that leaves it up to the best judgment of the filer. The birth certificate is not a safe harbor option. So, again, even with a safe harbor option, it may be necessary to file one or more name variations as separate debtors, because it really is left to the best judgment of the filer based on the available evidence. The birth certificate is part of that evidence, but it is by no means determinative of what the correct name of the debtor is for purposes of the safe harbor options.
Okay, thank you. So that is all the time we have today. If we didn't get to your question, and I know that there are many that we did not get to, we will contact you with a response after the webinar. Thank you to everyone who joined us today. We hope to see you next time.